Good afternoon. Thank you for joining us today. We're so grateful to have all of you with us. We'd like to welcome you to Lynn Cancer Institute Updates, what you need to know in 2021. Today, Elsa Raynor and Julie Katz, licensed clinical social workers at the Lynn Cancer Institute, will be educating us on advanced directives. Voice your choice. I just have a few housekeeping notes before we get started. In the interest of time, Elsa and Julie's bios were sent to you by email. Your Zoom will be muted during this presentation. We invite you to please take notes on this very important information, and if you have a question, please put it into the chat box or the Q&A. Elsa or Julie will not be able to see you or hear you during their presentation, so your questions must be written in order for them to see the question and respond. At the conclusion of their presentation, there will be time for the questions to be answered. And we'd like you to also keep in mind that Elsa or Julie are unable to answer any questions of a personal nature on this broadcast. We will also provide you with an evaluation form. These evaluations allow us to add your name and email address for future mailings, as well as address any suggestions that you might have for us. On Monday, Lee Jensen will email an evaluation and a link to our presentations that are posted on our website. Now, we're very proud to welcome you to the Lynn Cancer Institute and to introduce Elsa Raynor, licensed clinical social worker in the Oncology Support Services Department and the CINDY program at the Lynn Cancer Institute. Elsa will provide an overview of the history of advanced care planning, landmark cases, and important terminology for us to all know. Welcome, Elsa.
Thank you, Jan. Good afternoon. Before I begin, Julie and I want to thank you first for joining us. Talking about end-of-life decisions can be a sensitive topic, but it's an important one, so we sincerely commend you for being here. So today we're hosting this webinar from a cancer center, but this discussion is for anyone at any time with or without a health concern. Our hope for all of you today is to gain a better understanding of what advanced directives are, why they are important, and how they came to be. Stating our end-of-life wishes is our right, and with this right comes responsibility. This responsibility falls upon us to decide and express what our wishes are, and this responsibility may also fall upon us if we are in a position to speak on the behalf of our loved ones regarding what their wishes are. So our agenda today will include why this presentation is being offered on this day, an overview on the history of advanced care planning and landmark cases that impacted advanced directives. We're going to discuss the difference between advanced care planning versus advanced directives, review different kinds of advanced directives, and last but certainly not least, we will review the components of having end-of-life conversations. So let's begin with why today. We are offering this webinar today because both National Healthcare Decisions Day and Donate Life Month are in the month of April. In fact, today, April 16th, is designated as National Healthcare Decisions Day. The purpose of these events is to inspire, educate, and empower the public and providers about the importance of advanced care planning. These events and supporting organizations have contributed to emphasizing the importance of end-of-life decision-making, but they came to be after a very long history. As you will see, this is not a new topic. There is evidence dating back to biblical times, with burial wishes being expressed to family members at their bedside. Nearing death, Jacob expressed to one of his sons where he wanted to be buried. His son promised he would honor his wishes and ensure that his possessions were appropriately distributed. If we fast forward to the 1900s, there is a documented legal case from a patient versus the Society of New York Hospital regarding the removal of a tumor that a patient did not consent to. Ultimately, the patient lost this case, but the presiding judge made a statement that helped shape the view of patients' rights. The judge stated that every human being of adult years and sound mind has a legal right to determine what shall be done with his own body. Jumping to 1969, a law was put into place stating that a patient may not be subjected to treatment without his consent. But the challenge was what to do about patients who no longer were capable of making healthcare decisions. The lawyer in this case suggested individuals should put in writing ahead of time the extent to which he or she will consent to treatment and refer to this potential document as a living will. So these were some of the seeds that were planted that slowly began to take root regarding the importance of end-of-life discussions, but there were also more recent landmark cases that significantly impacted discussions surrounding end-of-life decision-making and contributed to the development of laws that we have today. As I'm reviewing these cases, I will be using the term healthcare surrogate. Julie will go into more detail about what this is, but a short definition is a healthcare surrogate is someone who is named by the patient to communicate on their behalf what their wishes would have been under certain medical circumstances. First, we have Karen Ann Quinlan, who in 1975 lapsed into a coma after being out with friends, and her condition was diagnosed to be irreversible. Her parents believed she would not want to be kept alive by machines, but these wishes were denied. This court case became the center of a national debate on the definition of life and the right to die. Eventually, a unanimous decision was ruled and appointed her father as her guardian. This case led to the requirement that all hospitals, nursing homes, and hospices have ethics committees, and this case further emphasized the need to create living wills. Next, we have Nancy Beth Cruzan, who was in a car accident in 1983 that left her in a persistent vegetative state. Her parents attempted to terminate the life support system, but state hospital officials refused to do so without court approval. Since she did not have a living will, nor a designated healthcare surrogate, there was no formal record of her wishes. The court did find that she had once discussed termination of life support with a roommate, indicating that she did not want to live in a vegetative state. The court accepted this conversation as sufficient evidence of her wish not to be maintained on life support, with the court ruling that competent individuals have the right to refuse medical treatment. This case resulted in a federal law called the Patient Self-Determination Act, which I will review shortly. And last, we have Terry Schiavo. In 1990, Terry went into cardiac arrest and was ultimately placed on life support. Terry's husband and her parents disagreed about what decisions Terry would have made. After 3 years of no meaningful recovery, her husband accepted the diagnosis that her condition was irreversible. Recalling a statement that his wife had once made, which was, "I don't want to be kept alive on a machine," he refused life-sustaining measures on her behalf. However, her parents vigorously opposed their son-in-law's decision. After years of litigation, Terry's husband's decision was honored. This case, an example of the importance of naming a healthcare surrogate who would be best suited to make end-of-life decisions, as Terry's husband believed he was the most appropriate and her parents believed they were. But because Terry did not officially name a healthcare surrogate, the courts were forced to choose. So we will never know who Terry would have wanted to make those decisions. So we can only imagine what these individuals experience as patients. But there are also the years of turmoil, court proceedings, and grief experienced by their families and their loved ones. So here are some of the pictures of families along with the number of years they fought for what they thought their loved one would want. My point for reviewing this history is to emphasize that patients and families before us have struggled and fought. They fought for their loved ones and for themselves, but ultimately they fought for us too. In each of these cases, a healthcare surrogate was not specified by the patient. Perhaps some of the angst could have been reduced or at least reconciled by these families if a healthcare surrogate was named. I want to take a moment to review the order of who would be called upon if a healthcare surrogate is not named. So there are a tier of individuals or a pecking order that would be considered to speak on your behalf if you were unable to. So first, it needs to be cleared that there isn't a court-appointed guardian. If there is, this person would be the primary decision maker. If there isn't, the order is spouse, adult children, parents, adult siblings, adult relatives, and close friends. So now this brings us to a federal statute called the Patient Self-Determination Act. Earlier, I spoke about our rights in end-of-life decisions. This act helps to allow for our decisions to be documented. This act went into effect in 1991 and focuses on advance directives and the rights of adults to refuse life-sustaining treatment. The law applies to all healthcare institutions receiving Medicare or Medicaid funds, including hospitals, skilled nursing facilities, hospices, home health and personal care agencies, and HMOs. This is why you are asked in certain medical settings whether or not you have advance directives. Despite all of these efforts, statistics show there is still a disconnect between what we know is important and what we actually do. Let's consider these statistics. 90% of people say that talking with their loved ones about end-of-life care is important, but only 27% have actually done so. 80% of people say that if seriously ill, they want to talk to their doctor about their wishes for medical treatment toward the end of their life. Only 7% report having had this conversation with their doctor. 60% of people say that making sure their family is not burdened by tough decisions is extremely important. 56% have not communicated their end-of-life wishes. 82% of people say it's important to put their wishes in writing, but only 23% have actually done so. So this leads to the question, why is there such a huge disparity? So here are some examples of some reasons why we avoid having conversations about end-of-life decisions, and perhaps some of you can relate to this illustration. So some of these reasons are talking about death is frightening, I don't want to add to stress, I'm young, there's no need. Perhaps there are faith and religious belief concerns or conflicts, feeling uncomfortable, or believing it's the doctor's job. And there is one reason that tends to come up quite frequently, and that is, I don't need to do this right now, that I have time. Well, this line of thinking prompted the phrase, it always seems too early until it's too late. When we recall the three women in the cases shared earlier, their ages were 21, 25, and 26, all young women for whom end-of-life planning was important. So now I'm going to segue into the language of end-of-life planning. Most likely everyone here today has heard the term advance directives, but it's also important to know about the term advanced care planning. Advanced care planning is the process of understanding, reflecting on, and discussing your experiences, your values and beliefs in an effort to identify how you want to live if faced with a serious or life-limiting illness. So it's both an internal process of reflecting on personal experiences and an external process of communicating and discussing your personal wishes. Advance directive is a documented statement of a person's wishes regarding medical treatment, often including a living will, and this is made to ensure that those wishes are carried out should the person be unable to communicate them. It is important to know that advanced care planning comes first. The advance directive document is the outcome of this planning. Oftentimes, the focus is on the paperwork, but we want to emphasize the importance of the planning.
Thank you, Elsa. I was so engrossed there. Now I would like to turn it over to Julie Katz, licensed clinical social worker in the Oncology Support Services Department and Classic program at the Lynn Cancer Institute. Julie will go into more detail about advanced care planning, advanced directives, and how to have the conversation so you can voice your choice. Welcome, Julie.
Thank you, Jan. So how do we plan for our care in advance? Advanced care planning involves learning about the types of decisions that might need to be made. Then we consider those decisions, inform our family and healthcare providers about your choices, and finally, write down your choices into an advance directive, which is a legal document that goes into effect only if you are incapacitated and unable to speak for yourself. The intent of advanced care planning is to ensure that patients receive care that is aligned with their goals and values. Advanced care planning is applicable to adults at all stages of life. Participation in advanced care planning has been shown to reduce stress and anxiety for patients and their families and lead to improvements in end-of-life care. That is so important. I want to say it again. Participation in advanced care planning has been shown to reduce stress and anxiety for patients and their families and lead to improvements in end-of-life care. Active discussion about an individual's goals and preferences, specifically as they relate to end-of-life issues, is linked with many positive outcomes. Reductions in hospitalizations, reduction in aggressiveness of care at the end of life, increased use of hospice services, decreased family conflict, a greater likelihood of persons receiving the care that they want, and dying in one's preferred place of death. Making healthcare decisions for yourself or someone who is no longer able to do so can be overwhelming. That's why it's important to get a clear idea about preferences and arrangements while you can make decisions and participate in planning together. So for advanced care planning, we want to review the plans regularly, update documents as circumstances change, put important papers in one place, and make sure a trusted family member or friend knows the location of and any instructions. Make copies of healthcare directives to be placed in all medical files, including information on every doctor seen. Give permission in advance for a doctor to talk directly with a caregiver as needed. And finally, reduce anxiety about funeral and burial arrangements by planning ahead. The next step after having the conversation is the documentation process. This is where advanced directives come in. The types of advanced directives we will be discussing today include the designation of healthcare surrogate, a living will, and a DNR or DNRO. These are some types of advanced directives that you might come across. The first picture is the designation of healthcare surrogate, and the 5 wishes is a type of living will. The designation of healthcare surrogate designates a surrogate decision maker in case you cannot speak for yourself. Make sure your surrogate understands what you want for yourself. This can be done without a lawyer, and it should be shared with your healthcare team. A living will can be extensive or minimal. It provides an outline of what you would want if you cannot speak for yourself. It lists medical treatments you would or would not want if you became seriously ill or unable to make your own decisions. Both of these, healthcare surrogate document and a living will both require two witnesses. At least one of the witnesses cannot be a spouse or a blood relative. The person designated as your surrogate cannot act as a witness to the signing of the document. Neither of these forms need to be notarized. A DNR or DNRO is a do not resuscitate order. It's usually reserved for those suffering from a terminal condition, an end-stage condition, or for someone who's in a persistent vegetative state. This is a physician's order, and it's part of the prescribed medical treatment plan. It must have a physician's signature. It's a yellow form, and it should be readily available, and others should be informed that it exists and of its location. Now, let's talk a little more in depth about do not resuscitate orders. These indicate that the person does not want CPR or a ventilator. CPR, let's talk about it. It can sometimes restart a stopped heart. It's most effective in people who are generally healthy before their heart stopped. During CPR, we've all seen it on TV, the medical professional repeatedly pushes on the chest with great force. Electric shocks, called defibrillation, may also be used to correct an abnormal heart rhythm. Sometimes the force required for CPR can cause broken ribs. CPR often does not succeed in older adults who have multiple chronic illnesses or who are already frail. Now, if a patient has very severe breathing problems or has stopped breathing, a ventilator may be needed. The ventilator forces the lungs to work. It involves intubation, which is putting a tube attached to a ventilator down the throat into the trachea or windpipe. Because this tube can be quite uncomfortable, people are often sedated. If the person needs ventilator support for more than a few days, the doctor might suggest a tracheotomy, sometimes called a trach. A tracheotomy can carry risks, including a collapsed lung, a plugged tracheotomy tube, or bleeding. So these are all things to consider when signing your DNR. As adults, when do we think and talk about what we want? So this should begin at the age of 18. It should continue, and you should have the conversation at the start of each decade of your life around any major life event, such as getting married, divorced, or widowed, the birth of a child, going to college, even planning for a major trip. And finally, if you're diagnosed with a serious illness, all of these situations should inspire conversation and consideration. Questions to consider when choosing your surrogate. Will the person make decisions that follow your wishes? Will the person be comfortable making quick decisions in a challenging situation? Will the person be a good advocate? Will the person be comfortable speaking up on your behalf? Your advocate may need to make decisions on your behalf, even if their own wishes are different than yours. This may be emotionally difficult for some people. Your advocate should be someone who could understand your values and wishes in any situation. That way, they can make decisions more easily about the kind of care that's right for you. Your advocate doesn't need to be a medical expert, but they may need to make quick decisions as information becomes available about your care, such as whether to give you antibiotics for an infection or whether to insert a feeding tube if you can't eat. So let's talk about voicing your choice, picking your person. Start by asking if the person is comfortable taking on this role. You can say something like, I'd like you to be my healthcare surrogate. That means you would be the person who would make medical decisions for me if I can't make them for myself. I would share what matters to me in my care so you wouldn't have to guess. Is this something you would be comfortable doing? Now, you listen. You listen to the person's answer, you answer any questions they have. It's okay if they need to say no. Talk about what it means to be a healthcare surrogate. They would have the legal power and responsibility to make medical decisions for you if you are unable to make them for yourself. They can talk with your doctors, read your medical records, and make decisions about tests, procedures, and other treatment. They are entitled in the United States to full access to your medical information under HIPAA. They will need to ask questions and get information to make decisions for you, and at times they may need to advocate for you. Make sure your surrogate understands what matters to you. It's really important to talk with your surrogate about what matters to you, about the kind of healthcare you'd want now and through the end of life. When these conversations happen before a healthcare challenge or crisis, it will be easier for your surrogate to make decisions for you when it becomes necessary. If you envision any potential conflict, let everyone know. Let everyone know what your decisions are, what's going on, so that it can minimize the conflict. Finally, we can't plan for everything, but we can talk about what is most important in our life and in our healthcare with those who matter most. Know what you want. Let others know what you want. Speak up and voice your choice. Here are some links and resources that Elsa and I thought were helpful. You can, I'll pause a minute, you can take a picture, or you can refer later to the recorded webinar. Finally, here's a little Snoopy cartoon that we thought was applicable. Someday we will all die, Snoopy. True, but on all other days, we will not. Thank you very much.
Thank you, Julie, and thank you, Elsa. That was very comprehensive and a lot for us to all think about. We do have one question, a couple of questions. What is the difference between a healthcare advocate and a healthcare surrogate?
Okay, that's a really good question, and it does tend to come up quite a bit. So there are several names, depending on what state you're in, on who that healthcare surrogate or healthcare decision maker is. So again, in the state of Florida, we are calling it a healthcare surrogate. In another state, it could be a healthcare decision maker. Another kind of clarification with an advocate is sometimes we'll hear the term advocate. Well, this person is my advocate, or, you know, I'm bringing in this person as my advocate. So your advocate could be someone who you bring to you to your doctor's appointments, perhaps to speak for you, to help clarify, but that doesn't necessarily mean that that is the person that you have designated as your healthcare surrogate.
Okay, thank you.
You're welcome.
And how does one set up a DNR, and can it be changed over time?
So a DNR is a physician's order. So it can only be done with your physician, and it's usually done at a time when you need it. It's not done in advance. You can't do one when you're 18 for the future. So can you, what was the second part of the question, Jan? Sorry.
Oh, can it be changed over time?
It absolutely, you can tear up your DNR if you decide against it. If you change your mind, you can absolutely, you are entitled to change your mind at any time.
Okay. All right. That looks like you covered everything in such great detail that those are the only questions that we have. So we thank you both so much. We learned really so much from you today, and we're so grateful. And if anybody thinks of any questions after they're thinking about this presentation, you can send the questions to me, and I can forward them to Elsa and Julie. All of our lectures are recorded. So this presentation, as well as all the ones that we've had in the past, are posted on our website. so you can go back and watch it, share it with your family and friends. Lee will send you the link in her follow-up email. We appreciate everyone that has joined us today, and we hope to see you next Friday, April 23rd, where Dr. Sahil Chowdhury will educate us on benign brain tumors and meningioma. Thank you, Elsa and Julie, and everyone have a great afternoon and a great weekend. Thank you for joining us. We really appreciate it. Bye-bye.
Thank you, Jan.
Thank you.